What recalls the case of the people of the state of Michigan versus Henry McKean Shapiro.
Good afternoon, Your Honor. Robert Lee on behalf of the people.
This is where everything changes. What started as a criminal case now pivots into something just as serious, a bond revocation hearing. And let's be clear, bond conditions are not suggestions. They are court orders. When a defendant is released on bond, the court is essentially saying, we trust you to follow these rules while your case is pending. The moment that trust is broken, freedom is back on the table. Here, the prosecution is arguing that Henry McKean violated a very specific restriction. He was only allowed on the University of Michigan campus for class or employment, not socializing, not activism, not posting flyers, class or work, period. And the twist? They have photographs, time-stamped, location confirmed, plus his class schedule showing he had no reason to be in that building. That combination, visual evidence and documented schedule, is powerful in a bond violation context. The standard here isn't beyond a reasonable doubt. It's much lower. The stakes, jail, immediately, graduation on the line, judicial trust shattered. And the judge in this courtroom, Judge Simpson, is known for taking court orders seriously. The question now isn't whether he was there. It's whether the judge believes this was careless or willful. And that distinction is everything.
Lauren asking on behalf of Mr. McKean Shapiro, who stands to my left.
All right, this is the people's motion regarding revocation of bond. Go ahead.
Yes, Your Honor. Thank you. Your Honor, on September 17, 2024, this defendant was given a set of bond conditions. One of those conditions was that the defendant could be on the U of M campus only for the purposes of attending class and or for the purposes of employment. On March 28, 2025, which people have articulated in their motion, the defendant violated that specific bond condition. He was photographed in Angel Hall, putting up flyers at approximately 10:25 a.m. He did not have a class in Angel Hall. He was not working at Angel Hall. He had no purpose to be there, and therefore the people believe that it was a violation. Attached to our motion, we have attached several documents. One was the bond order, which outlines the conditions that he was governed to by this court. The others were photographs of the defendant on March 28 at Angel Hall, putting up those wanted flyers. We also attached the defendant's class schedule. His class schedule indicated that he did have class that day at a different building, that being the MLB building from 9 to 10. And after that, according to his own response, he had a quiz that he was supposed to take, but that quiz was also in that same building. He had no purpose to be in the Angel Hall building at all. He was not there for class. He was not there for the purposes of employment. He was photographed there putting up posters, but I really don't even think that is the issue. The issue is that the bond conditions of this court is that he's only supposed to be on campus for the purposes of employment and or class. And clearly the photographs indicated that on March 28, 2025 at approximately 10:25 a.m., he was not doing either of those things. And so, Your Honor, with that, we request that the court does find that there is a violation, and how the court needs to deal with the violation, we need to discuss.
Thank you. Saskia.
My client is acknowledging that he did violate the bond conditions. Although he was on campus for class and he went there to study, he does acknowledge that he had no purpose to be in that building, although he was there to seeing friends for a moment. So although he was there and he was there during a break, he was not supposed to be in that particular building.
Notice something critical here. The defense does not fight the violation. They admit it. That's strategic. In bond hearings, credibility matters more than combativeness. By acknowledging the violation up front, the defense avoids antagonizing the judge and instead shifts toward damage control. But here's the problem. Even a small violation can be treated as a major breach. Courts view bond compliance as a test of discipline. If a defendant cannot follow a narrow location restriction, what does that say about future compliance? And this wasn't accidental wandering across a property line. The judge later makes that distinction clear. This was a specific building, at a specific time, doing something unrelated to class or employment. Let's pause here. Do you think posting flyers during a break is harmless? Or does a rule become absolute once a judge signs it? That tension between technical violation and perceived fairness is exactly what makes this hearing dramatic. Because now the issue shifts from facts to character.
Accept the admission of the defendant to the bond violation. Mr. McKean Shapiro, anything you want to tell the court before I impose sentence?
No, thank you.
All right. Well, let me just tell you this, sir. Throughout this entire case, I've been taking it at a pace, particularly so that you know, recognizing that some of you as students were set to graduate. You were one of those. I either have to believe that you just through some willful and wanton reason just decided you wanted to violate this court's order. And in that way view you as one that I certainly have to protect the public. On the other hand, I almost want to think about you as just being stupid. And I hate using that word, but this is just absolute stupidity. When I saw the photographs of what you were doing, and understand, I'm not going to issue a sanction because of the content of those flyers and the speech that may be in that, as vile as it is. I'm not doing it for those reasons. I'm doing it because you have to understand that in some way you have to conform to rules. Somehow or another, from the very beginning of this case up until that date, you were able to do it. And I don't know how you just lost your mind that day and just decided you were going to do something else. I told your counsel when we were back discussing it in chambers, and I'll just make it real clear, that upon seeing that, unless you gave me some good explanation, I was just going to send you. You were just going to sit till this case ended.
That statement right there, that's a warning shot. Judge Simpson is revealing something important. He seriously considered jailing this defendant until the entire case concluded. That could mean weeks, even months, in custody. Not as punishment for the original charge, but purely for violating bond. This is where judicial discretion becomes very real. Bond revocation isn't automatic. Judges weigh intent, public safety, prior compliance, and credibility. And listen to the language he uses, willful versus stupid. That's not casual phrasing. He's deciding whether this was defiance or recklessness. Also notice the judge makes a constitutional clarification. He's not punishing the content of the flyers. That's significant. Courts must avoid even the appearance of penalizing speech. This sanction is about location violation. It did not expression. So when he says he doesn't issue orders, he doesn't intend to enforce. That's institutional authority speaking. Here's the turning point. The defense attorney in chambers convinced him not to jail the defendant outright. That tells you advocacy mattered. But the judge is still deciding what consequence restores authority without being excessive. And that balance is razor thin.
You need to thank your attorney that she was able to convince me that maybe that wouldn't be the best thing in the world. Because I don't issue orders I don't intend to enforce. You violate them, I'll hear you out. I'll allow you that due process to be able to explain to me what happened. I think as Mr. Macklin, when he was arraigning before, I have difficulty sometimes with these orders regarding the U of M. I grew up in Ann Arbor. I understand that sometimes you can be walking around, you're on city property, the next thing you know, you're on university property. I get all of that. That wasn't this. You were someplace you weren't supposed to be, quite frankly, doing something you shouldn't have been doing given the circumstances that you're in at this time. Where is your graduation going to occur?
One is off campus, and there's another in the big house area.
Where?
The Michigan State Theater.
But that's a UM sanctioned event.
I don't believe it's university property, though.
Okay, man. I get that. But the event is being put on by the university. Right?
Correct.
And here lies the problem. Tell me how I can trust you to behave yourself, not only just on university property, but at any university event.
I have no intention of attending that event for any other reason than receiving my diploma.
Why am I supposed to, how am I supposed to believe you? See, that's what the problem is here. You're asking me to trust you. How am I supposed to trust you?
This is the emotional core of the hearing. Bond is built on trust. Once broken, the defendant bears the burden of rebuilding it, and the judge is openly struggling with that. He's not debating the violation anymore. He's debating reliability. What's powerful here is the graduation element. Judges often consider life milestones in sentencing decisions, but they also weigh accountability, and Judge Simpson makes it clear graduation was almost forfeited. Did you catch the shift? The judge moves from legal analysis to personal impact. He brings up the father in the courtroom. That's strategic rhetoric. He's reframing the violation not just as disobedience of court orders, but as jeopardizing something meaningful to the family. Would you have given him the chance to attend graduation? Or would a violation automatically cancel that privilege in your view? This is courtroom psychology in action. The judge is signaling disappointment, not rage. And disappointment from the bench can sometimes be more powerful than anger. Now we're approaching sentencing, and based on the tone, it won't be nothing.
At the moment that I receive my diploma, I will not have any more contact with the University of Michigan in any regard.
That's the only ceremony you were attending?
That was the only one I was planning on attending.
So you are not going to the one at the stadium?
No.
The other thing that your attorney convinced me not to do, because quite frankly, I was concerned certainly about those of you that were graduating initially when this case came along. Very concerned in making sure that you got there. But your behavior, in my mind, almost had you forfeit that right to be at that graduation. Basically, just sort of flushing down the toilet, if you will, the symbolic representation of the time that you spent. But your attorney pointed out something to me, because your dad's here. And I guess sometimes what kids don't realize is you're getting that piece of paper, but you're walking across that stage is more for them than it is for you. That's what you jeopardize for your parents. So the only reason that and I don't know your dad, I never met him, wouldn't be able to pick him out of the crowd that's out there, but I'm just going to tell you something. The only reason I'm fashioning something that allows you to attend that graduation is for your parents.
Much appreciated, Your Honor.
They shouldn't suffer because of your stupidity. Because that's something they never get back. But you're going to have to pay a consequence for it. Everybody else here has been able to conduct themselves as best I know in a fashion to comply with the court's orders. You did not. Your attorney has convinced me that sending you to jail for 10 days through the graduation commencement weekend would be unduly burdensome to you and your family. So here's what I'm going to do. I think it appropriate that you spend time in jail for violation of the court's orders. And I do consider it not just a violation of that order, but I consider it a willful violation that you did. You knew better.
There it is, the word that seals it, willful. When a judge labels conduct as willful, the penalty escalates. That means the court believes the defendant understood the rule and consciously chose to ignore it. But here's where the nuance comes in. Instead of the 10 days originally considered, which would have covered graduation weekend, the judge imposes 4 days. That's calibrated punishment. 4 days sends a message. Court orders matter. But it also leaves room for the defendant to attend graduation after release. Notice how today counts toward the sentence. That detail shows measured fairness. And then comes the GPS tether. That's continued supervision. It prevents further campus violations and reassures the court that compliance will be monitored technologically. So the sentence accomplishes 3 things: punishment, deterrence, restoration of judicial authority. It's firm, but not maximal. And the immediate remand, that's real. No delay, no later surrender. Custody begins now.
So, Mr. Allen. So it's going to be the sentence of the court. You're going to spend 4 days in the Washtenaw County Jail.
This way.
Yes, sir. Oh.
Shame.
Stay here. Stay here.
Stay right there, sir.
Just stay still. Good. Good.
Do you have anything on you? Do you have anything on you?
Put your hand.
No.
You can put your hand.
You're going to spend 4 days in the Washtenaw County Jail. I'm going to release you after those 4 days. So that you know, today counts. So it's not like 4 days from today. Should be out Sunday. You'll be out, you'll be placed on a GPS tether for your location to make sure that you do not enter any University of Michigan property. So be careful when you're walking, once you're out, when you're walking around, that you don't just stray there, because particularly down where your commencement is, you know what I'm talking. There's areas that are U of M property. You understand that?
Understood, Your Honor.
Okay, defendant is remanded. Folks, before you get up, would you have a seat, please? Understand something. All of these things are difficult. You may not like the court's rulings. A lot of thought has gone into them. I need you to also understand that while that defendant did what he did and he took responsibility for it, I also have 6 defendants that have properly followed the court's orders and have not placed themselves in any jeopardy. What happened in that case is he did it to himself. But anybody that wants to have an outburst, you can have an outburst all you want, but you're just going to be removed from my building. I'm not going to tolerate it. It's not fair to these defendants as well as Mr. McKinney Shapiro to have their case properly heard. So I'm going to expect that everyone will conduct themselves in conformity with it.
Judge Simpson closes this hearing with something larger than this one defendant. He addresses the entire courtroom. That's a signal this ruling carries broader weight. 6 other defendants complied with bond conditions. This defendant did not. The judge makes it clear, consequences are individualized. What happened here wasn't arbitrary, it was self-inflicted. Legally, this was a straightforward bond violation supported by photographic evidence and schedule records. The defendant admitted the breach. The court found it willful. The result? 4 days in jail, credit for time served starting immediately, and post-release GPS monitoring to prevent future violations. But the broader implication is institutional trust. Courts operate on structured freedom. Break the structure, and freedom contracts. This case reinforces a critical lesson. Compliance with bond conditions is not flexible, even for brief detours or seemingly minor actions. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.